Hussainara Khatoon and others versus Home Secretary, State of Bihar, Patna. In this case, which is considered as one of the first public interest litigation of India, in this case, petition for writ of habeas corpus discloses a shocking state of affairs in regard to administration of justice in the Bihar state. An alarmingly large number of men and women, children including, are behind prison bars for years awaiting trial in court of law. The offences with which some of them are charged are trivial, which, even if proved, would not warrant punishment for more than a few months, perhaps for a year or two, and yet these unfortunate, unforgotten specimens of humanity are in jail, deprived of their freedom for periods ranging from 3 to 10 years without even as much as their trial having commenced. It is a crying shame on the judicial system which permits incarceration of men and women for such long periods of time without trial. Some of the under trial prisoners whose names are given in the newspaper cutting have been in jail for as many as 5, 7, or 9 years, and a few of them even more than 10 years, without their trial having begun. What faith can these lost souls have in the judicial system which denies them a bare trial for so many years and keeps them behind bars, not because they are guilty, but because they are too poor to afford bail and the courts have no time to try them? It is a travesty of justice that many poor accused little Indians are forced into long cellular servitude for little offences because the bail procedure is beyond their meager means and trials don't commence, and even if they do, they never conclude. In this case, court directed that all women and children who are in the jails in the state of Bihar under protective custody, or who are in jail because their presence is required for giving evidence, or who are victims of offense, should be released and taken forthwith to welfare homes or rescue homes and should be kept there and properly looked after. Court also directed the government of Bihar to scrutinize the cases of under trial prisoners charged with offences which are punishable with fine only, or punishable with imprisonment for a term not exceeding 1 year, or punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years, and release such of them who are not liable to be proceeded against by reason of the period of limitation having expired. Due to this writ petition considered as public interest litigation, more than 40,000 prisoners were released whose trial didn't begin at that time.